Order. We now have Chuka Amuna to move the motion.
Thank you very much, Mr Walker. And I should say at the outset, I'm very pleased that it's the Minister for Corporate Responsibility responding to this debate today, because having responded to the debate I held in the last Parliament earlier this year, she will be familiar with the issues that I am raising. For the benefit of the record in this Parliament, I just want to recap what it is that we are talking about here. Imagine you have spent years acquiring the skills to work on construction sites around the country. No one ever complained about the quality of your work or your work ethic. You happen to be an active member of your trade union, keen to ensure that you and your colleagues had a safe and pleasant working environment, nothing out of the ordinary. And then on one occasion, you raised a serious health and safety concern, no small matter, given that an average of 39 construction workers are killed at work every year in the UK. But ever since you raised that complaint, you have not been able to get work. That is what happened to thousands of construction workers for decades in this country. They were blacklisted, and no one has ever been brought properly to book for it. I'll give way to my honourable friend.
People who have been blacklisted in construction, who have raised those issues of health and safety, far from being barred from employment, does he agree with me that they should be commended and saluted?
Absolutely. I couldn't agree more with my honourable friend, and I will outline some of the things that people have done and campaigned on for justice on this matter. Blacklisting is the shady, underhand practice of sharing information on workers without their knowledge and then systematically denying them employment on that basis of that information. These practices first hit the headlines in 2009 when the Office of the Information Commissioner raided the premises of a disreputable organisation called the Consulting Association. What they found when they raided that association was a blacklist of over 3,000 construction workers. The association was funded and used for years by over 40 of the country's construction firms, biggest construction firms, to vet employees. The association, set up in 1993, was the successor to another disreputable organisation called the Economic League, which I'm sure my honourable friend, the member for Erdington, will mention later. The construction companies fed the association detailed information about workers without those workers' knowledge. And whenever they made hiring decisions, they checked applicants' names against the association's list. If you were on it, you were usually refused work. You were denied the ability to do your job and provide for your family. Essentially, the system facilitated the systematic victimisation and denial of work simply because workers had raised legitimate health and safety concerns in the past or because they were a member of a trade union or a political party. It was and still is an outrage. And the nature of some of the information about people held on that blacklist, for example, their religion, their national insurance number, car registrations and so on, strongly suggests that the data on the list was collected with the collusion of the police and/or security services. That is why it is entirely fitting that the Blacklist Support Group members, many of whom are here, have been granted core participant status in the Pitchford inquiry into undercover policing. Those who suffered and are victims now have three principal routes for redress. The Employment Relations Act 1999, Blacklist Regulations 2010, which now outlaw blacklisting. But these came into force too late for those who suffered at the hands of the Consulting Association. There is the Trade Union and Labour Relations Consolidation Act 1992, which stops people being discriminated on the basis of being a member of a union. And then there is the Data Protection Act 1998, which can be used against those who abuse and misuse people's personal data. I'll give way very shortly. The late Ian Kerr, who was Chief Officer of the Consulting Association, was fined a paltry £5,000 after the ICO's raid, because only later were the fines levied under that Act substantially increased. I'll give way to my honourable friend.
My constituent, Sandy McPherson of Ilkley, was one of the plaintiffs to the recent case. Does my honourable friend agree that there is a strong case now for making blacklisting a criminal offence with strong criminal sanctions, including big fines and possible imprisonment in the worst cases?
I do. I wholeheartedly agree with my my honourable friend. And he talks about the litigation. In July 2014, Balfour Beatty, Carillion, Constane, Keir, Lang O'Rourke, Sir Robert McAlpine, Skanska UK and Vinci plc, who were all involved in blacklisting and in funding the Consulting Association, they established a compensation scheme for individual workers affected by blacklisting and made an apology of sorts for what happened. But their scheme was unilaterally established without the agreement on the terms with the trade unions representing the workers, and other firms who were part of the hall of shame involved with the association, such as Amett Group, Amy Construction, BAM Construction Limited, Morgan Sindall and Taylor Woodrow Construction, they didn't sign up to the scheme.
Will my honourable friend give way?
I'll give way to my honourable friend.
I'd like to thank my honourable friend for giving way, and as he knows, this is an important issue to me as I represented blacklisted UCAT members in the High Court. Does he agree with me that no firm involved in historic blacklisting should be given a public contract until they demonstrate the regret for their actions by supporting a public inquiry, offering retraining to victims and demonstrating that their recruitment processes are transparent and fair?
I completely agree with my honourable friend and commend her and the huge team of people who, of course, worked on all of the litigation that we have seen in the High Court, brought by a number of unions, including the UCAP, part of Unite Now, which I'm proud to say is headquartered in my constituency, and, of course, the GMB. These unions deserve huge credit for the efforts that they put into uncovering exactly what went on, but then getting redress, working with my colleague, my honourable friend and others, in the courts as well. Now, these cases have been settled over the last 2 years, and millions have been paid. But the fact remains, not one director of the firms who funded the Consulting Association has ever been properly brought to book, fined, or subject to any individual court sanction for the misery they visited on construction workers over the decades. No one has been brought to book properly for this. In fact, we are behaving as if all has been forgiven. Tears were apparently shed last month over the fact that we will not hear Big Ben's bongs for several years. Now, we should be far more concerned by the fact that Sir Robert McAlpine, a firm implicated in all of this, appears to have bagged the work that is to be carried out on Big Ben Tower to fix those bonds. A multi-million-pound contract. And let us be clear about the role that Sir Robert McAlpine as a company played here. Colin McAlpine, a director of Sir Robert McAlpine, was chairman of the Consulting Association when it was formed in 1993. Later, David Cochrane, the head of HR at that firm, he was a successor as chair of the association. And during a hearing of the Scottish Affairs Select Committee inquiry into all of this in 2012, the late Ian Kerr, who died that year, admitted that his £5,000 fine for breaches of the Data Protection Act was met by Sir Robert McAlpine. He said that they were met, and I quote, on the basis that I had put myself at the front and took the flak, if you like, for it all, so that they wouldn't be drawn into all of this. They would remain hidden. Now, how in light of this can we as parliamentarians sit here and say this is all an outrage to the victims, many of whom are watching this debate in this chamber, while standing by as Sir Robert McAlpine are awarded this contract to do this work on this parliamentary estate? There must be consequences when you bid for public contracts and you are found to be involved in these types of practice. So can the Minister, when she gets up, explain why on earth Sir Robert McAlpine are to be awarded this contract to fix the bongs on Big Ben that so many parliamentarians were shedding tears about? Why on earth are we giving them this contract, given their disgraceful role in blacklisting? Now, I took up this issue originally principally as a constituency issue, having been alerted to the scandal by my good friends at Unite. I took an even stronger interest in this issue when I was the Shadow Secretary of State for Business and instigated the first full debate on this topic on the floor of the House in 2013. As I said earlier, I instigated another debate earlier this year on this because we have got to have a proper public inquiry into blacklisting, and the victims are continually denied this.
Just on that point.
I'll give way to my honourable friend.
I'm grateful to my honourable friend for giving way. One of my constituents, Alan Wainwright, is a victim of blacklisting and was party to exposing the blacklisting as a whistleblower on this issue. He has submitted a file of evidence to the Minister's office on that very point about the public inquiry. Would my honourable friend agree that the Minister should look at that seriously and examine that in detail as part of the inquiry?
I completely agree with my honourable friend. I've met with his constituent myself. And, you know, in the end, the reason we need this is that we need to know who knew this was going on. It wasn't just happening in the private sector, it was happening in the public sector. You know, there are allegations that it was going on the Olympic sites, on Portcullis House, Ministry of Defence sites, but who knew it was going on? Did the permanent secretaries know? Did the ministers at the time know? Were the departments commissioning construction projects complicit in all of this? We don't know. Does the law need to be changed? Does it need to be tightened? To what extent is this still going on? Now, the Coalition and current Conservative governments, each time we've debated this here, have specifically refused to set up that public inquiry on the basis that they say there is little evidence that blacklisting is still going on. Well, today I want to present compelling evidence to the Minister which shows this practice is definitely still going on, and it is happening on one of the biggest construction sites in Europe, Crossrail, a publicly funded project which I have myself visited. Let us not forget that one construction worker died after being crushed by falling wet concrete in March 2014, and 2 other men were seriously injured in separate incidents in January 2015, working on Crossrail tunnels around the Fisher Street area in central London. In July just past, the contractors concerned, BAM, Ferrovial and Kier, the BFK consortium, pleaded guilty to 3 offences following an investigation by the Health and Safety Executive, and they were fined more than £1 million. The Health and Safety Executive said that had simple measures been taken, such as having properly implemented exclusion zones in high-hazard areas, all 3 incidents could have been prevented. This illustrates why it is so important construction workers should feel free to raise health and safety issues without fear of retribution. I'll give way to my honourable friend.
I'm most grateful to my honourable friend for giving way, and in fact he almost makes the point I was going to make. He has outlined the human cost of the blacklisted workers and their families. But isn't there a more sinister reason as well, which is of intimidating legitimate trade union activity so that they can boost profits, often at the cost of the lives of their own workers?
Well, I think the behaviour, I think my honourable friend makes a very good point there, because to what extent is profit being put before safety here? Why is there such paranoia when employees and workers raise these issues? I find it hard to fathom, given when you look at the fatalities that are occurring in the construction sector. Now, the first case I want to mention to the Minister concerns the surveillance of workers that took place at a peaceful demonstration at a Crossrail site in 2016. I have seen and read the emails that passed and were circulated between contractors and the Employee Relations Department at Crossrail, which details questionable surveillance practices. These surveillance operations involved named individuals who were implicated and involved with the activities of the Consulting Association. The evidence which I will supply after this debate to the Minister illustrates that a number of construction workers were being closely watched there and sensitive personal information was being collected in relation to them. It is not clear where this data was subsequently posited or precisely by whom, but those collecting the information on the workers had to fill in a form which was definitely filed somewhere. 2 of the workers concerned, who were subject to that surveillance, have since sought to obtain further employment on Crossrail and did so through employment agencies advertising positions after this surveillance of them. In each case, they approached the job agency with regards to the vacancy. They had the required skills to fill the vacancies. However, as soon as they relayed their names, there was a delay, and then they were subsequently given an excuse as to why the positions had been filled. Now, Unite has already informed the Office of the Information Commissioner of their concerns with regards to this first case I'm talking about. They don't believe it is coincidental what happened to these two particular workers. Subcontractors were clearly, explicitly discouraged from employing certain no trade union members. One subcontractor has actually told Unite that the consequences of him employing a Unite member would be the refusal of future work, and for obvious reasons that subcontractor does not wish to disclose their identity. The Office of the Information Commissioner, having been contacted about this, has stated that this evidence, and I quote, raises the possibility that surveillance is being undertaken without appropriate checks and balances being in place, and that the, and I quote, collection of this type of data is potentially excessive under the law. The second case I wish to highlight is that of an electrician who's been trying to obtain work in the construction industry since raising a grievance whilst working on Crossrail. He has since applied for hundreds of job vacancies, almost always being turned down. He never received any criticism about the quality of his work. This guy is an intelligent guy, very conscientious about his work, and in particular he takes the health and safety of he and his colleagues very seriously indeed. He's not particularly political. He's a construction worker. That is the focus of his work. He had served Crossrail with a subject access request which compelled Crossrail to provide him with the information they held on him. I've been passed the documents and I've had a chance to read them myself. They reveal Crossrail and 3 of its contractors exchanging personal data and sensitive personal data concerning this individual's previous employment and the issues and grievances he had raised there. On the face of it, the data appears to be processed for the purpose of determining the individual's suitability for employment related to his trade union activities. The very strong inference from the documents is that some kind of vetting operation was in operation between Crossrail, its contractors and the agencies involved. Again, I will pass this information and the documents on to the Minister after this debate. Now, these are just 2 examples, but clearly they show that blacklisting is still going on. I don't think it is being carried out in the way that it was before, with a centralised system, collectively funded by the construction companies, not least because if you're caught now under data protection legislation, as I said, there is a much bigger fine. And, of course, we have the blacklisting regulations which are now in force. But clearly, it is still being done, but in a more covert way, making it a lot harder to identify. The Information Commissioner has said it will put out a call for evidence next year on ongoing blacklisting. They should really get on and put out that call for evidence now without further delay. But that is no substitute for the public inquiry we seek, because the ultimate way to get to the bottom of what did happen and is still happening is by having a proper investigation like that. My own view is that the law clearly needs to be reviewed, in spite of the Minister saying to me earlier this year that is not necessary. I would like to see workers given a positive right not to be blacklisted. I think the suggestion that was made by my honourable friend that this should be made a criminal offence is well made. And I'd also like to see protection against blacklisting extended to include trade union-related activities as opposed to the current definition, trade union activities. I'll give way to my honourable friend.
Thank you. Does my honourable friend agree with me that we should commend the work of trade unions on this issue? The GMB, for example, has already secured 630,000 in my own region of Yorkshire, but it's clear that there is still more to do.
That's absolutely right, and I think all members of this House who have spoken on this issue, done any activity on this issue, we would have found it very much harder to do what we've done without the trade unions providing the support and the information and uncovering what happened. And I have to say to the Minister, I just don't understand why the government and the Minister's department are so resistant to having this public inquiry. What are they so afraid of? What are they so afraid of? At the end of the 2010-2015 Parliament, I made it very clear to her department, which I was hoping to run after the election, that if we won the election, I would be giving instructions for the establishment of such a public inquiry. I was very clear to the Permanent Secretary. It can be done. It needs to be done. And above all, the thousands of people here who have suffered need this to be done. And they need it to be done at the same time that those who were ultimately responsible for all of this have got off scot-free. Yeah. Now, I've provided the evidence to the Minister orally, and I will provide the documents so she can see them in detail, that this is still going on. But I say to her and this government, a government that claims to be one that looks out for the interests of workers, put your money where your mouth is. Deliver on this public inquiry, and let's get justice for those who have suffered and those who are still suffering.
The question is that this House has considered blacklisting. Are there any colleagues who would like to follow on before we go to no colleagues standing? Right, well, Mr. Mann.
I may make one commentary on a public inquiry, and that is, of course, there could be reasons why the government's a little bit reluctant, because if you look at history, of course, there were previous blacklisting organisations, and we know of the unanswered questions, or rather unjustly resolved questions relating to Shrewsbury in 1973, and we know about the Economic League blacklist. And I would put it to my honourable friend to the House and also to the Minister that we shouldn't be scared of taking this on. I believe there's been people working inside Parliament who were part of creating the Economic League blacklist, working for MPs, using the facilities inside it. And what's to say that they have not actually continued those activities? Because the same companies come up. And it's all sorts of people. You know, I think there's a bit of a view of some of the naive MPs that perhaps this is something to do with, you know, extreme militants battling away. Let me tell you one extreme militant who was on the Economic League blacklist and refused a job because of it. That's me. Now, I don't probably fit the normal view of being an extreme militant. Some would say far from it. I'll leave you to make your own judgments on that. However, when I got given a job by Ciba-Geigy in Manchester in the 1980s, the job got withdrawn from me, which was a bit of a surprise. So I asked him why. He says, you give me a job, and now you've taken it away. He says, you're on some list, and I'm afraid, very apologetic, we can't give you it. And then by some coincidence, someone got hold of this list, and I remember it very vividly. There were a meeting at the University of London Union. Ricky Gervais, I think, was the events officer there at the time. Anyway, it was the list, and it was made public. So you went in this student room, and there were desks there. So I thought, well, I'll go see, nosy in and have a look. And I went through, and I looked under them, and I found my name there. Now, I've no idea why I was on the Economic League blacklist. I don't know who put me on it, or why. Frankly, it hadn't affected me, because I wasn't that bothered about the job. So it didn't like some people, where it's blighted their lives and their income and their families ever since. But I'd have only actually known that if the person telling me had pointed it out to me apologetically. They could have easily not said a word and says, no, we ain't got the money, there's no job there, sorry, no contract signed, and I wouldn't have known. And if I hadn't gone along to that, I saw it in I don't know where I saw it, somewhere, and I read it was on, I thought I'd stick my nose and have a look. If I hadn't gone and had a look at these lists, as you do, curiously, it's a bit of a shock when you find your name on a list, and you wonder who is it who put it on. Well, I'll tell you, because I did some research then, some good publications from the time. A lot of names of the people in the Economic League, some of those people working for Tory MPs in here, and the Tory MPs in the middle of it. So, public inquiry, let's have everything revealed. Let's go all the way back, and those that haven't got justice, don't bother about me, I'm all right. But Shrewsbury, for example, and all the way through the 70s and the 80s as well, construction, but not just construction, let's have some justice there. There's a lot of people out there who don't even know why they didn't get the job they went for. And I tell you today, it'll be the NHS and parts of the NHS as well, not just construction, where this kind of informal blacklisting is going on, and therefore it's crucial. We changed the law, so let's get on with it, let's have an inquiry.
In this debate, my honourable friend from Bassetlaw mentions the Shrewsbury case. The alleged conspiracy took place in my constituency, in the Bull and Stirrup. It was then a bunch of fellows trying to defend their livelihoods, and that continues today, 40 years later. And in fact, my honourable friend leading the debate, and I pay tribute to him for his persistence in this, mentioned the attitude of the Minister and the government in this case, which is that they don't want a public inquiry because blacklisting has stopped. But whether it's a Shrewsbury case 40 years ago or workers today, even if blacklisting had stopped, the effects of it are still there, and the poverty and the shame and, frankly, the humiliation of men and women, decent, hard-working, skilled men and women who have been denied that livelihood and who are suffering the economic consequences of it ever since. So the effects are still with us, and the human consequences are still with us. And the sense of injustice, above all, is still with us. And we cannot turn our back on the sense of the injustice, whether it's the family of Des Warren and Ricky Tomlinson in my constituency 40 years ago, when it wasn't my constituency, but I'll still lay claim to it, or whether it is the men and women who have suffered perhaps thousands and thousands of pounds worth of financial loss, and heaven knows what kind of human psychological damage, who are still living with the consequences of that today. So even if the blacklisting isn't taking place, and I'm minded to agree with my honourable friend from Streatham that it is, even if it isn't, the consequences are, and I believe the government has a responsibility to address those current consequences.
I just want to make a couple of very quick comments, if I may, Mr Walker. I wasn't intending to speak in detail, but given there is time, I will do so. First of all, I happen to be the Member of Parliament for 6 of the members of the Shrewsbury group of individuals, and I know even today how they live with the consequences of that blacklisting, such as one of my colleagues has been the Labour Mayor of the town I live in, has been a Labour councillor, served on the police authority, but even today cannot travel to the United States because of the conviction that took place at that time, because of their investigation into a whole range of matters to do with health and safety in the workplace, and the allegations that were made at the time, which the government still need to address, about the information the government holds that it could publish about the records of the Shrewsbury 24 at that time. So I would ask the Minister to look at that issue in general terms, and to again revisit what was visited very strongly in this chamber in the last Parliament about the consequences of the government not releasing information to do with the Shrewsbury 24, which the government promised to release and which the government have failed to release. But the main reason I wanted to stand, Mr Walker, is simply to say this. I was approached in the last few weeks by my constituent, Alan Wainwright, who is a victim of blacklisting and who was part of the whistleblowing of the blacklisting exposure that's taken place. Last Tuesday there was a Guardian article which detailed Mr Wainwright's experiences, and he has produced a detailed report of his experiences with his dealings with the trade unions and with his dealings with business, which he has submitted to the Minister's Department for her to examine. He has also submitted it to the General Secretary of Unite, Mr Len McCluskey, who himself has ordered an inquiry into this matter within the Unite Union. But I would just simply like to ask the Minister what Mr Wainwright asked me to ask the Minister, which is, will she look at and confirm that she's received that report, will consider that evidence, and will look at a possible inquiry into all the allegations that he's made, in addition to the points made very ably by my honourable friend, the member for Streatham.
Thank you, Mr Walker. When I was a young trade unionist, there was a feeling about that those people that were blacklisted or sacked on strike were generally revolutionaries and pretty bad people in the main. Now, I rather suspect that that view still harbours in the dark corners of some people's minds. But nearly 40 years ago, I was the works convener in a medium-sized factory, and after a 19-week strike, the employer decided to sack me for being nothing more than the works convener of the people that had been on strike. Now, people may well have said at that time that I was a pretty aggressive individual and might well have deserved it. But the reality is, my wife and 2 little children hadn't done anything wrong. And I never really got over the fact as to why I should be victimised in that way. Now, earlier this year, Mr Walker, Prince Charles, on the instruction of the Queen, knighted me, as you say, as Sir David Crosby. So I asked the question, in the long term, who was the villain? Me as a Member of Parliament, or the employers who decided to victimise me, but also, I think much more importantly, my family.
A little extra time, so I'm going to allow each front bencher from the opposition 7 minutes, and that will give the Minister a little longer as well if she requires. So, Mr Stevens.
Thank you, Mr Walker. Can I firstly congratulate the Right Honourable Member for Streatham for giving a very vivid account of blacklisting in this country. Mr Walker, I've argued since the general election that in this House of Minorities that there is potential for this Parliament to be called the Justice Parliament. And that is ensuring that there are inquiries to deal with the Shrewsbury conspiracy, or the wrongful conviction of minors during the miners' strike, and in this issue, blacklisting, as well as those caught up in contaminated blood. And whilst there is now the start of an inquiry in contaminated bloods, which I welcome very much, I do support the efforts of the Right Honourable Member for Streatham and others to have a public inquiry on blacklisting. Blacklisting is covered, Mr Walker, in a fantastic film called The Happy Lands, which is based in Fife, the historical context being the general strike, and there, in that film, blacklisting is revealed. Mr Walker, it's difficult to comprehend the extent of blacklisting in this country, thanks to the levels of denial and secrecy surrounding this odious practice. But what's not difficult to understand is the dreadful effect and suffering that blacklisting has on people's lives, not just the workers targeted for their trade union activity, but their family members as well. Denial of the most basic of human rights, the right to work and provide for your family, by the same companies that have grown rich on lucrative public sector contracts is a shameful act and an abuse of power. Because make no mistake, Mr Walker, blacklisting is a deliberate decision taken by company directors and managers who are in the business of maximising profits for shareholders by punishing those who seek to stand up for their rights and the health and safety of their fellow workers. And the Honourable Member for the Bassett Law gave, I think, the account he's given in his personal circumstances is commonplace in the construction industry, where people turn up for work and within a day or two are told that there's no longer a position for them because companies have been looking at that blacklist. We are clear in the SNP, Mr Walker, that blacklisting in any form is unacceptable and will not be tolerated. Now, despite employment law being a reserved matter, which I think is unfortunate given the consensus of Scotland that it should be devolved, the Scottish Government's introduced legislation, the Public Contracts Scotland Regulations 2015 and Procurement Scotland Regulations 2016, which came into effect in April last year. These changes will ensure that any company in Scotland found to be involved in the practice of blacklisting will be excluded from bidding for public sector contracts. The General Secretary of the STUC, Graham Smith, has welcomed this action, and he has quoted as saying that he welcomes particularly that any company applying for new public contracts where blacklisting has taken place in the past must make an apology to the affected workers, issue a statement of future conduct and prove compliance with any tribunal ruling made against them in relation to blacklisting. Mr Walker, I share the concerns of the Right Honourable Member for Streatham about the delays to 2018 as Unite the Union have flagged up. That's just another pathetic Brexit-induced stalling in my view, but yet another kick in the teeth to those who want not just justice for past wrongs, but security for present and future workers. Some of the context for that move towards greater transparency has come through action through the High Court, and in an attempt to body swerve liability, a number of construction companies attempted to almost name and shame themselves. Lang O'Rourke, Christine Keir and Sir Robert McAlpine, who I'll come on to later. Now let's make a mental note of the last company named there. As one of the directors already mentioned, Callum McAlpine was interviewed under oath by the Scottish Affairs Select Committee when it conducted its inquiry into blacklisting. And as an important aside, I do hope that the Scottish Affairs Committee now go back to that inquiry, which was chaired by my predecessor, Ian Davidson. The 3 interim reports all made clear that there is a case for a full public inquiry and that is essential if we are ever to expose the true extent of the practice and take measures to stop it. To return to the company of the founding member of the Consulting Association, Sir Robert McAlpine, Callum McAlpine refused to answer many of the questions put to him by the Scottish Affairs Select Committee members and relied heavily on his lawyer for advice throughout that session. Despite which, though, he was forced to admit that the company had used the blacklist to vet workers on the Olympic Stadium. In light of this, it's more shocking, as the Right Honourable Member for Streatham has rightly said, that they've been awarded a £20 million contract for Big Ben, a contract to refurbish one of the most iconic buildings in the country that symbolises the seat of power and London as a global destination. Mr Walker, I'm calling today for McAlpines to be stripped of that contract. It is an absolute disgrace and scandal that they were awarded that contract in the first place, and that none of the actions that are taken in Scotland are not happening here at Westminster. And the government should be looking at what the devolved administrations have done in regard to looking at companies and public sector of those who have been engaging in blacklisting. It signals bad faith to one of the main perpetrators of this conspiracy, and blacklisting is a conspiracy, are accessing public money to boost its profits. I too support the Honourable Member, the Right Honourable Member for Streatham in relation to a public inquiry. I hope that the government will announce that public inquiry into blacklisting, because there are many, many unanswered questions in relation to that. So, Mr Walker, I congratulate once again the Right Honourable Member for Streatham and all those who have spoken so far, and they have the support of the SNP for a public inquiry into blacklisting.
Exactly 15:15.
Thank you very much, Mr Chairman. Can I first of all congratulate the Right Honourable Member for Streatham for his outstanding advocacy of a noble cause. Trade unions are a force for good. To be denied work because you are a trade unionist is an affront to democracy. Neither is blacklisting history. Blacklisting is a scandal which has never gone away. Now, 40 years ago, when I came out of the Grunwick strike, I was blacklisted by the Economic League. I was one of the 30,000 subversives, as they defined it at the time. For me, I was out of work for a matter of months, but I then became an officer of the Transport and General Workers Union. But for tens of thousands of others, they paid a very heavy price, some of them for decades. I then worked with The Guardian to expose the Economic League, leading ultimately to their demise, but it was absolutely scandal that they were then reincarnated as another organisation practising the same practices. Mr Chairman, it's absolutely scandalous that 2 generations on from the 1970s that we still have an industry, the construction industry, which has not learnt the lessons of history, has not recognised that, as Keith Ewing, the Professor of Public Law at King's College London, described blacklisting as the worst human rights abuse in relation to workers in Britain in half a century. Now, blacklisting has been outlawed by the law, but the law is simply not strong enough. There has been some compensation for some of the victims of blacklisting, but it's not good enough. And in particular, that cynical manoeuvre, which was about trying to protect public scrutiny, escaping their crimes being made public. And no user company has been punished for their actions for blacklisting. No director has ended up in the dock, and that is completely wrong. Now, the scale of blacklisting over the years is tens of thousands of workers. And I have to say, with a long history of government, police and construction firms acting in collusion. And what we've heard today from the Right Honourable Member for Streatham is that blacklisting is happening right now on the part of major and allegedly reputable companies enjoying enormous public contracts, be it Crossrail on the one hand or Big Ben on the other. Mr Chair, it is important that we reflect on the human consequences of that on a continuing basis, and we've heard powerful testimony of that today. For workers, they have a pride in their work. They define themselves through the job that they do. It's about self-worth, identity. To be out of work for years, not quite knowing why, and then discover it's because you did nothing else but to ask for a safe workplace, is an absolute scandal. And if I can just give one example.
I'm grateful for giving way. My constituent, Danny Regan, was an electrician until he was blacklisted. He isn't an electrician anymore, and he still can't work in that field because of the history of blacklisting. And so, in supporting the call that's been made today for a public inquiry, does he agree that it needs to address that legacy of the impact of what happened in the past?
Yes. Without hesitation, and I will come to that very issue, Mr. Chairman. If I can give one human example. I know over the years hundreds of individuals have been blacklisted, but just give one human example here today. Dave Smith, the Joint Secretary of the Blacklisting Support Group. Dave became virtually unemployable as a consequence of his file, first held by the Economic League and then the Consulting Association. His file was 36 pages long, stretching from 1992 to 2007. From his very first job with Balfour Beatty all the way through successive employment. And on Balfour Beatty, his sin was to take part in a dispute about unpaid wages. The file included all his personal information, address, national insurance numbers, history, but also details of his wife and brother as well. Mr. Chair, this is an absolute affront to democracy and the rights of working people, and it demands further action. And what the speakers today have absolutely right when they say that what we need first and foremost is a public inquiry into the issue of blacklisting, its use in the past, its current use, and steps going forward to eradicate blacklisting, the role of the Special Demonstration Squad, the role of the Consulting Association, the examination of evidence of blacklisting on publicly procured contracts. The truth needs finally fully to be told. Secondly, we need to strengthen legislation to stop the continuing practice of blacklisting, the criminalising blacklisting, but also ensuring that the law is not just limited to employment relationships, because by definition, if a worker is blacklisted, then he or she doesn't have an employment relationship. It's also, as Unite have argued, about tackling patterns of work, in construction more generally, bogus self-employment, that argument which says that you have 10 million workers now in insecure employment where employers can abuse without fear, and very often blacklisting follows. Thirdly, we need stronger rules, Mr. Chair, on government contracts being awarded to firms complicit in blacklisting. There has to be consequences for blacklisting. McAlpine, one of the first blacklisting offenders, it is a scandal that the Big Ben contract has gone to that company. I suspect here we don't give a damn about the Big Ben bong, but what we do give a damn about is that this firm that blacklisted workers, treated them shamefully, has got an iconic contract, but yards from where we are here today. So what we need is effective action, including at local authority level. I praise Liverpool in particular for their social value charter, which talks about respect of all of individuals and does not engage in any form of discrimination or blacklisting practices. In other words, the sending of an unmistakable message which has to be enforced, that if you have blacklisting or are suspected of blacklisting, you do not get public contracts. And fourth, of course, we need to make sure that specific laws banning blacklisting and data protection are retained after leaving the European Union. If I can say this in conclusion, as we've heard here today, blacklisting is not history. We need to learn from the lessons of history, ultimately confine blacklisting to history. That's why we need that public inquiry, the strengthening of the law, and absolute clarity. You don't get public contracts if you blacklist. And if I can say this, Mr. Chairman, the time has come to blacklist the blacklisters.
Before the Minister starts, can I just ask her to leave a minute or two at the end for Mr. Amuna to sum up? Thank you. Minister.
Thank you, Mr. Walker. It's a pleasure to serve under your chairmanship. And I first congratulate the Honourable Member for Streatham for securing this debate and also for his opening remarks, which I listened to intently. I'm pleased to have the opportunity to respond to this debate, and I do want to make clear that the government take the issue of blacklisting extremely seriously. We hope and trust that blacklisting has already become and will remain a thing of the past, but we are not at all complacent, and I am even less complacent, having heard what I've heard, particularly from the honourable member who introduced the debate, about evidence that he wishes to put before me after the debate. I was shocked by what I heard, and I share his view and that of other members that blacklisting of trade union members and activists is completely unacceptable. It has absolutely no part to play in modern employment relations. We have in place, as honourable members have noted, regulations that are targeted specifically against trade union blacklists, and I believe that these regulations are both proportionate and robust to prevent the abuse occurring. I accept the point that has been made that the abuse, the horrendous abuse of the past, which was very overt and organised and clearly in breach of the law as it stands today, there is a risk that that sort of overt abuse may have been replaced by a more covert approach, and that has to be borne in mind. But the blacklisting regulations introduced in 2010 has made it unlawful for an individual or organisation to compile, sell or make use of a blacklist of trade union members or those who have taken part in trade union activities. Since the introduction of those regulations, there has not been any evidence presented to government or to the Information Commissioner that these practices are recurring, and naturally, if that is no longer the case, I want to know about it. Any individual or trade union that believes they've been the victim of blacklisting practices has the right to take action. They don't have to wait for any independent investigation. They can enforce their rights in the regulations through the Employment Tribunal or the County Court. Anyone who believes they've been affected has the right to pursue justice through these means, and we would encourage them to do so. The measures in the Blacklisting Regulations 2010 are reinforced by powers in the Data Protection Act 1998, which protect the use of personal data, very much needed in the examples that we've heard about this afternoon. I'd like to emphasise that this includes information on trade union membership and sensitive personal data. The government takes the protection of personal data very seriously indeed. The Information Commissioner's Office is the regulatory body set up to investigate breaches of the Data Protection Act, and it has the powers to take enforcement action, including searching premises, issuing enforcement notices and fines now of up to £500,000 for serious breaches. And the government continues to bear down on those who seek to exploit personal data. We have published a statement of intent in relation to the proposed Data Protection Bill, which was announced in the Queen's Speech. The bill will implement the General Data Protection Regulation into UK law. The new bill will give us one of the most robust and dynamic sets of data laws in the world. It will give people more control of their data, require a higher standard of consent for its use, and prepare Britain for exiting the European Union. As a result of the General Data Protection Regulation, the Information Commissioner's fining powers will substantially increase from May 2018 to either 4% of annual global turnover of an organisation or of €20 million, or whichever is the greater. It is clear that data collection and data analytics in the workplace are gaining in importance, and in light of this and the strengthened framework that the General Data Protection Regulation will create, the Information Commissioner's Office will intend to open a call for evidence, which honourable members have alluded to, on the implications of modern employment practices in recruitment and selection and the obligations of employers. Now, the honourable member says that this should be happening sooner rather than later. I agree with him. I believe the call for evidence is scheduled for next year. I will talk to the Information Commissioner's Office to see if this can be brought forward. This call for evidence is an important step in not only trying to establish the true picture of the level of blacklisting which may or may not take place in practice now, but also how growth in digital services has created potential new risks for employees and how these may be addressed. I will.
In my previous capacity as on Suffolk County Council, when Suffolk County Council decided to outsource its highways to Kier, we took a motion to Council calling for them to ensure that there was no blacklisting with employees of Kier working for Suffolk County Council. This motion was passed unanimously because Conservative members on Suffolk County Council, like I'm sure the Conservative members of this Parliament, were vocally opposed to blacklisting. However, nothing was done to find out whether or not blacklisting was actually taking place. And you're talking to us about search for evidence, but surely without a public inquiry to find out what has actually taken place, Minister, there is no way you will actually get to the bottom of this. Minister.
I thank the honourable member for his intervention, and I could reassure him that if people in his borough have any evidence, then the best thing they can do at the moment is to take it to the Information Commissioner, who will investigate it. In fact, the Information Commissioner doesn't need particular examples even. If they are having allegations made against a particular employer or within a sector, then they will commit to investigating the issues that his constituents have raised. I'll give way one last time and then I must conclude.
The honourable member who's just spoken in the last intervention has mentioned procurement. So can the Minister tell us what steps the government's taken in terms of procurement to make sure that companies who are blacklisting workers are not getting public sector contracts?
Minister. I will write to the honourable gentleman on that matter. We do expect high standards of corporate governance in major contracts that the government awards. And if there is evidence that companies are acting in the present day in a not only disreputable but potentially illegal manner, then that would be taken into consideration. The call for evidence is...
Point. We've heard powerful evidence today in relation to both Crossrail and Big Ben. Does the Honourable Lady agree that if there is evidence of complicity in blacklisting, that the companies concerned should not get public contracts in future until such time as they have remedied the bad practices of the past and indeed the present?
The Shadow Minister makes a very reasonable point, which I will consider further. I think there is nothing to disagree with in what he has said. We want to build upon the work already undertaken by the Information Commissioner Office looking at profiling and big data analytics. The Information Commissioner's call for evidence, once complete, will be the most recent and authoritative source of data that we have. And I can assure you that the Government will consider the evidence that they collect and their report upon it very carefully indeed. I want to acknowledge the request from the Right Honourable Member for Delham. I have indeed received correspondence from Mr Alan Wainwright. I have looked at it briefly and I will examine it thoroughly. And also he asked me to look again at the situation with regard to the Shrewsbury 24, and I will write to him on that subject as well. The Government will continue to take a very close interest in this matter, and if the Information Commissioner finds any evidence of current blacklisting, perpetrators can expect to feel the full force of the law, and I am sure, going back to the Shadow Minister's intervention, that this would have implications for contracting as well. In the meantime, in the absence of clear, strong and compelling evidence to the effect that blacklisting is widespread, we remain of the view that the blacklisting regulations, alongside the proposed changes to the data protection rules, are appropriate and robust tools. The increased fines and accountability are further disincentives to counter this abhorrent and illegal practice. And the call for evidence I would urge all members to talk to their constituents that raise these matters with them, talk to the trade unionists in their constituency who have been affected, and use this call for evidence as a means of exposing any current practice that might be continuing, so that we can eradicate this appalling abuse of people's human rights at work once and for all.
Mr. Miller, would you like to just wind up for a minute or so?
First of all, I'm very grateful to all the members that have contributed to this debate and the powerful testimony that several have given. I'll just say three things. I welcome, first of all, the Minister saying that she will press the Information Commissioner to do this call for evidence this year and not next year. And I also welcome the fact that she has said, that, and if I heard her correctly, the government is going to consider taking into account whether people were involved or are involved with blacklisting in public procurement decisions going forward. That is most welcome indeed. The second thing is, look, in this industry, clearly there are good and bad sides. I've seen some of the good sides in my constituency over the last couple of weeks, visiting big construction sites on Streatham High Road and the Clapham Park estate, which will make a positive difference to my community. But what this scandal exposes is the ugly underbelly of this sector, which continues to go unaddressed. And I'll just wrap by saying this to the Minister. She accepts that this is an outrage, and she has said that the government takes this seriously and is not complacent about it. I still fail to understand why today she was not able to come here and commit to that public inquiry. I don't understand what it is the government is so afraid of. If it exposes embarrassing things for people politically that happened in the past, well, so what? Surely justice is the key here. That's how we prove that this Parliament is relevant, and that actually, for all the bad press that this place gets, and for, given how disillusioned people are with the political process, at least with this we can illustrate that we deliver the goods and care about people. So I ask her, please think again about this issue of doing the public inquiry. Don't be scared. Just announce that you're going to do it.
Hear, hear. Hear, hear. This House has considered blacklisting. As many of that opinion say aye. Of the contrary, no. I think the ayes have it. The ayes have it. Order, order. Sitting stands adjourned.